We really support one another. We're always working side by side. Like that unforgettable rooftop scene in the movie? My husband actually wrote that. No one really knows that, except you now. But he wrote it. He's involved in everything I do, just like I help with everything he's doing. So when he has a win, when there's something to celebrate, it's mine too. And when I succeed, it's his celebration as well. He's woven into every part of this film. Now, Hugh Jackman? He's not a part of the film, but he's very much present at this premiere, and I'm really thankful for that. Hey friends, welcome back to my channel. So over the weekend, actually Friday night, Jed Wallace filed his updated complaint. But that's not even the biggest thing. You're not going to believe what happened. Do you all remember that back in 2015, Ryan Reynolds said he got hit by a car? He claimed it was a paparazzo, a well-known one based in Vancouver. This guy worked on a Canadian entertainment show, kind of like their version of E.T. His job was to snap celebrity photos for a number of media outlets. Ryan said this man hit him with a car. The guy was arrested, and then, a couple of years later, the charges were dropped. Does that sound familiar? Ryan had gone public about it, saying he had a sore knee and everything. Well, here's the twist. That same photojournalist reached out to me. We had a really lengthy conversation. And now, I'm combing through a massive amount of material he gave me. Based on the evidence so far, it looks like Ryan and Blake may not have been honest about what happened. Eventually, the charges were dismissed because no actual evidence backed up the claim. From everything I've seen so far, it looks like they tried to destroy this man's career, very much like what's unfolding now with Justin Baldoni. There seems to be a pattern here. Apparently, in the Canadian case, statements made to the authorities were also false, or at least that's what this new information suggests. So this alleged behavior, misleading officials and using influence, might not be isolated to the US. It seems there's a track record stretching across borders. There's more. The photojournalist? He spent years photographing Ryan and Blake for various assignments. He was on set for multiple productions in Vancouver, witnessing firsthand how things went. And what he shared paints a complicated picture of their relationship. There were reportedly ongoing issues between the two, Blake and Ryan. A lot of jealousy. Ryan would even show up on set just to keep an eye on her. This wasn't a one-time thing. It's been going on for quite a while. And it's not exactly a secret. People on set don't talk about what they see, mostly because of NDAs. Now, on the legal side of things, Jed Wallace has officially filed an amended complaint against Blake Lively, and it's happening in Texas. The reason he's filing there is straightforward. That's where he lives. A large portion of this updated complaint focuses on proving that Blake came to Texas and attempted to take legal action there. That, according to Wallace, is why Texas holds jurisdiction. He also claims that Blake used what he refers to as a faux complaint, not an actual legal filing, but rather a draft that lacked critical elements required to make it a formal legal complaint. This draft, he says, became the foundation for defamatory claims. Blake maintains that she never defamed him, but Wallace argues that this particular draft, shared with the New York Times, was both unofficial and unnecessary. Within that document, she allegedly made statements about him that were false and damaging, violating his privacy in the process. According to Wallace, everything changed for him on December 20th, 2024. That's the day Lively's draft complaint was published by the New York Times. It wasn't a formal legal complaint, it was only a draft, but it named him directly and included serious accusations. He outlines in his filing that prior to this, Lively submitted a 3-page employment complaint to the California Civil Rights Division. That complaint named Wallace and another party, Street, accusing them of sexual harassment and retaliation after she reported the incidents. Attached to the CRD complaint was a 62-page draft containing 203 numbered paragraphs. This draft identified both Wallace and Street as defendants and listed 10 allegations, ranging from harassment to breach of contract. It also claimed the harassment occurred during filming and that retaliation followed in the days just before the film's release. Wallace insists that neither he nor Street was ever present on set or involved in the film's production. Their only participation came after the movie premiered, when they helped with public relations efforts related to the film and its cast. The filings submitted to the agency weren't publicly available online. They could only be obtained through a formal written request for public information. And yet, on the very same night that the CRD and draft complaints were filed, at precisely 8:48 p.m., a reporter sent Wallace a detailed and urgent email. It spanned a page and a half and stated that the reporter had learned of a legal complaint filed by Blake Lively against him, alleging harassment and retaliation, among other things. The email referenced specific details from the draft complaint, including private text messages and emails. These messages reportedly involved Wallace, and the reporter claimed court records showed that his clients had included Paramount Pictures, a detail that was not easily discoverable. The reporter insisted on a response by noon Eastern Time the following day. By 5:26 a.m., well before noon, the same reporter's outlet published the contents of the draft complaint online. This document, again, was never formally filed in court but appeared on the newspaper's website, presented to the public under an official headline. The document still remains on the newspaper's website to this day. According to Wallace, it was Lively who provided the materials to the reporter and her publication. He clarifies that when he refers to Lively, he includes not only her directly but also her agents, legal team, consultants, husband Ryan Reynolds, and their associated companies, like Betty Buzz, Blake Brown, Aviation Gin, Mint Mobile, and Maximum Effort Productions. He explains that after the New York Times released the draft complaint, a wave of media coverage followed. Outlets such as The Hollywood Reporter, TMZ, E! News, Variety, Today, CNN, People Magazine, Fox News, and USA Today all ran stories focusing on the allegations. The next day, several Texas-based outlets also picked up the story. Wallace states that Lively shared the CRD filing and the draft complaint with multiple media contacts, though one publication received exclusive access to thousands of private texts and documents. This information was published in a detailed article within hours of the draft's release, under the headline, "We can bury anyone inside a Hollywood smear machine." Then, on New Year's Eve, the draft, which had grown into a 93-page document with 327 numbered paragraphs, was filed in the U.S. District Court for the Southern District of New York. However, unlike the CRD filing and the earlier draft, this formal complaint did not name Wallace or Street as defendants. Wallace asserts that Lively was fully aware of why they were left out, namely, that there was no evidence to support her claims against them. Street, in particular, had no involvement in the matter. 3 weeks later, Lively filed a separate lawsuit in Texas seeking evidence of Wallace's alleged involvement. She even hired one of Wallace's former attorneys to represent her in that Texas case. That lawsuit, filed in Hays County, was aimed at securing a deposition from Wallace. Lively testified under oath that she needed this discovery in order to assess potential legal claims against him. She also swore that if she pursued a lawsuit without this deposition, it would be baseless and considered harassment or filed in bad faith, violating Texas law. In other words, she asked a judge in Texas to grant her permission to gather evidence from a Texas resident, Wallace, to support claims she'd made in the California CRD and in the widely circulated draft. Wallace argues that this was a strategic move. Lively paid filing fees, retained 3 separate Texas-based law firms, and chose to act through the Texas legal system, all of which, he says, prove that she subjected herself to Texas jurisdiction. He goes further, pointing out that Lively traveled to Texas, including attending the South by Southwest premiere for another simple favor. While there, she was approached by a protester who accused her of lying and chanted, "Justice for justice." Wallace emphasizes that Lively didn't deny or respond to the claims, and she went on to interact publicly with personalities like Chip and Joanna Gaines. His argument is that her presence and actions in Texas show she actively engaged with the state, and that she should now be able to claim that Texas courts don't have authority over her. That's really the central thrust of what Wallace is trying to establish, that Lively can't argue a lack of jurisdiction after inserting herself into Texas legally and physically. What stands out the most, though, is Wallace's claim that Lively told the Texas judge she needed depositions before filing any lawsuit, otherwise it would be meritless under Texas law, and then, just 3 weeks later, she dismissed the lawsuit. According to Wallace, she falsely claimed that the federal judge in New York instructed her to drop the Texas case and refile it there for consolidation. But Wallace insists that's not what Judge Lehman said. Not even close. He says Lively made that claim falsely and without evidence. He argues that she knew full well that neither he nor Street had sexually harassed or retaliated against her or breached any contract, and yet, she still named both of them as defendants in the New York filing. That complaint accused them of knowingly violating her rights under California's Fair Employment and Housing Act, and doing so with malice, oppression, and fraud. What Lively is doing, Wallace suggests, is part of a larger pattern. He also mentions speaking to Omar, a legal expert from A Tilted Lawyer, who has been following the case closely. Jed Wallace also consulted a civil attorney, Omar from A Tilted Lawyer, over the weekend. During their conversation, Omar explained that Blake Lively appears to be engaging in forum shopping. This means she's attempting to take advantage of different courts in different jurisdictions based on what benefits she might gain in each. For instance, she used New York to obtain a subpoena, something she might not have been able to do under California's stricter laws. Similarly, in Texas, she filed a suit in order to gain access to information, but Texas law requires that such a lawsuit must have valid grounds, otherwise, it would be considered harassment or an act of bad faith. According to Wallace, Lively is now trying to have the Texas case dismissed by arguing that she was never really involved in Texas. He counters this by pointing out that when she filed her CRD, California Civil Rights Division, complaint, Wallace was explicitly named. He says the document blurred roles and failed to differentiate who was responsible for which actions. Instead, she grouped people under vague, sweeping labels like Wayfair parties or defendants. To the average reader, it appeared that Wallace was a clear part of the alleged misconduct. In her filings, Lively accused Wallace and another individual, Street, of acting despicably, maliciously, fraudulently, and oppressively with the intent to harm her. She even described Wallace as evil, alleging that he had no concern for her safety and deliberately caused her severe emotional distress. Additionally, she accused him of placing her in a false light, despite the fact that this claim isn't even recognized as valid under the laws of either Texas or New York. After filing her lawsuit and naming Wallace and Street as defendants in New York, Lively then appeared at South by Southwest in Austin, Texas, alongside her publicist Leslie Sloan and Jamie Kendall. While there, she was publicly confronted by a Texas resident chanting, "Blake lies. Justice for Justin." According to Wallace, she didn't deny or correct this claim, which he sees as allowing the defamatory narrative to continue by implication. Further, Wallace notes that she also publicly visited Chip and Joanna Gaines during that same Texas trip. On February 5th, he demanded that Lively retract or clarify her defamatory statements. Then, on March 7th, she used Texas law to formally request information from Wallace and his co-plaintiffs under the relevant statute. They complied with her request. But as of this lawsuit's filing, she has neither corrected nor walked back any of her claims, even though she is fully aware that Wallace and the others were not involved in any sexual harassment. Wallace also points out that under Texas law, had Lively issued a retraction, she could potentially shield herself from punitive damages, but she chose not to. The core of Wallace's defamation argument is built around the nature of the so-called draft complaint. He argues it wasn't a legitimate legal filing at all. It lacked essential legal elements such as the name of the court, a cause number, clearly identified causes of action, a prayer for relief, which typically outlines what damages are being sought, a proper signature block for her attorneys. These are key requirements for a valid lawsuit. While her lawyers' names were listed on the front page, which is common in California filings, it wasn't applicable or valid for New York, where the actual lawsuit was later filed. Wallace also argues that the draft complaint used vague, broad group terms like Wayfair parties, Wayfair team, tag digital team, and respondents and defendants that left readers with the impression that the serious claims, including sexual harassment and violations of California and federal laws, were being specifically pinned on him. He further asserts that many statements in the draft were outright false. For example, in just the first paragraph of the draft complaint, core allegations against Lively. Wallace's complaint paints a picture of defamation and strategic forum manipulation. Here are the key assertions. Defamation via draft complaint, not a legal filing. Wallace argues the draft complaint, attached to a California CRD filing, was not a legally required document. He contends it was a public relations tool, meant to attract media attention rather than fulfill a legal function. The document lacked court name, case number, prayer for relief, attorney's signature block. Despite being presented to the media as a lawsuit, it was not, and Wallace says this misrepresentation defamed him by stating or implying. He was retained by TAG to run a retaliatory social media campaign. He engaged in or contributed to sexual harassment and retaliation. He claims these statements are categorically false, except that he is a Texas-based contractor. Media strategy over legal strategy. Wallace points out that Lively allegedly prioritized media exposure over litigation. The New York Times published a story including the draft complaint within hours of its filing. This timing, right before a holiday weekend, suggests pre-release coordination. Wallace asserts the media could only have obtained the complaint directly from Lively or her agents, since CRD documents are not publicly accessible without a request. Metadata on a promotional video referencing the draft complaint further implies premeditated media rollout. Bottom line, the campaign allegedly sought public condemnation before legal adjudication. No factual basis / retraction avoidance. Wallace emphasizes that Lively later admitted she had no factual basis for her claims against him, still never issued a retraction or correction, despite having the opportunity, which could reduce liability under Texas law. He claims she used group labels and ambiguous language, e.g., Wayfair parties, that falsely implicated him in serious misconduct. Forum shopping / jurisdiction argument. Wallace accuses Lively of forum shopping, picking jurisdictions based on strategic advantage. She obtained subpoenas in New York for things she likely couldn't in California, filed a Rule 202 pre-suit deposition in Texas, then later claimed Texas had no jurisdiction over her. Wallace provides evidence of her active presence in Texas. Filing lawsuits in Texas. Paying court fees. Hiring Texas lawyers. Visiting cities like Austin and Waco, including public events and Book Bonanza. He argues these facts defeat her attempt to dodge Texas jurisdiction. 5. Private citizen protection. Wallace stresses that he is essentially a private citizen, not a public figure. His PR work is crisis-focused, e.g., helping Bam Margera return to film. He isn't someone who voluntarily placed himself in public controversy. Therefore, the bar for defamation is lower, and Lively had a duty to be more cautious in publishing allegations. This complaint positions itself as a pushback against misuse of media and legal privilege to smear reputations without proper legal grounding or factual support. Jurisdictional foundation looks solid. Lively's presence in Texas. She voluntarily entered Texas to file suit, serve subpoenas, attended events, visited public places like Waco and Austin, and engaged local legal counsel. Rule 202 deposition filing. She invoked Texas courts to gather discovery. That itself is a legal act that supports general jurisdiction under Texas law. Consistency argument. Wallace highlights the contradiction of Lively claiming Texas jurisdiction to obtain information, then disavowing it once sued. 2. Compelling defamation claim. Defamation per se. Accusations of criminal conduct, like federal harassment/retaliation, qualify as defamation per se in Texas, meaning no need to prove damages. Actual malice. The argument that she knew the statements were false or acted with reckless disregard is strengthened by her later statement that she needed discovery to confirm his involvement. Her omission of Wallace from subsequent lawsuits. Refusal to retract even after being notified. Lack of privileged defense. Wallace's position is that the draft complaint was not part of a legal filing protected by litigation privilege. It was not a formal complaint. It wasn't required for CRD. CRD doesn't evaluate or investigate the claims. The timing and media coordination point to a press strategy, not legal due process. Potential weaknesses/challenges. 1. Actual malice standard. While the facts may point to recklessness, courts are cautious in granting punitive damages without smoking gun evidence like emails/texts showing intent to defame. He'll need to show that she wasn't just mistaken, but knew the truth and proceeded anyway. Texas versus New York tug-of-war. Lively may argue that her contacts with Texas were peripheral or professional, that the center of gravity of the alleged harm, public impact, residence, reputational harm, lies elsewhere, e.g., New York or California. A Texas judge will have to weigh whether she is purposefully availing herself of Texas in a sustained, not incidental, way. First Amendment defense. If the judge finds her statements were opinion or protected speech related to a matter of public concern, e.g., #MeToo, she may try to use Texas anti-SLAPP law, TCPA, to dismiss. However, false factual assertions, especially with reputational damage, are not protected. Direct hit bottom line. Will it stick in Texas? Yes, Wallace has a viable, well-argued case in Texas, particularly on jurisdiction and defamation per se. His strongest arguments are her forum shopping pattern, her use of a non-legal document to trigger a media storm, her post-publication conduct, failure to retract, dropping his name in later suits. Whether he wins on the merits or not, getting past early dismissal and surviving jurisdictional or anti-SLAPP challenges is very likely given how much evidence ties her to Texas and how strategic her filings appear.